The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon, everyone, and welcome to today's webinar, Understanding the Impact of Medical Marijuana in Virginia. This webinar is being conducted for the Leading Age Virginia membership, and Whiteford, Taylor, and Preston is delighted to be an elite sponsor. Within 48 hours, you will receive a recording of this webinar along with a copy of the slide deck from the presentation. Before we get started, I do want to go over a few items so that you know how to participate in today's event. You have two audio options to choose from, computer audio or dialing in on the phone. To switch between the two, simply click on the circle next to your preferred audio option in the audio section of your control panel. You also have the opportunity to submit text questions to our presenters today by typing the questions into the questions pane of your control panel. You may send your questions in at any time during the presentation. We'll collect them and address them during a Q&A session at the end of the presentation. I would now like to introduce Tiffany Relaford.
Good afternoon, everyone. This is Tiffany Relaford from Whiteford, Taylor, and Preston. I'm here with my colleague, Mark Franco, and we are going to be presenting today on understanding the impact of medical marijuana in Virginia. So we are just going to roll right into it. Before we get into Virginia law, it's important to understand where medical marijuana is under federal law. Currently under federal law does not recognize or protect medicinal marijuana possession or use, and the federal government can prosecute people who are otherwise protected under state medicinal marijuana laws. So there's some conflict here between the federal law and the state law. While it's rare to face federal prosecution as an individual patient or as a member of a small medicinal marijuana growing cooperative, medicinal marijuana growers and dispensaries have recently received increased negative federal attention as a result of the conflict between the federal laws and the state laws. So why is medical marijuana, still not recognized or protected under federal law? Well, first, under federal law, under the Controlled Substances Act, marijuana is classified as a Schedule I substance. Well, what does that mean? Schedule I drugs are drugs that have a high potential for abuse and dependency with no recognized medical use or value. An example of a classification of that drug would be heroin. That's one of those drugs that has high abuse rates, and we don't see what the medical value is to the drug. So knowing this, any marijuana possession, cultivation, or use is a federal crime, subjecting a defendant to fines, prison time, or possibly both. But in spite of this, states have enacted laws that allow or protect the medicinal use of marijuana. And in those states, because of the conflict between the state law and the federal law, those states have decriminalized medicinal marijuana use, meaning they've removed the risk of criminal prosecution and penalties for patients who follow the law in their states with respect to amounts, registration, and any other requirements that the state law may have. But again, that's only protecting those individuals on a state level and not on a federal level. It's interesting to understand how the federal government has treated this issue. And under the different administrations, the trends toward it have somewhat been. Under the Obama administration, they had a hands-off approach to the actual enforcement of the federal law with regard to marijuana. In 2009, the U.S. Attorney's Office acknowledged that prosecuting those who are, quote, in clear and unambiguous compliance with existing state laws providing for the medical use of marijuana was not going to be one of their priorities. So in other words, I think they recognized that it's still a violation of federal law, but that wasn't one of their priorities to go after. Likewise, 2012, that office reiterated that in states that have enacted laws legalizing marijuana in some form, and that have also implemented strong and effective regulatory enforcement systems, enforcement of federal law related to marijuana was not going to be a priority. So again, recognizing the conflict here, but it just was not a priority for that administration. So when we turn into the Trump administration, they have somewhat been silent on the issue. But in 2017, President Trump did make statements that the Department of Justice may not use any funds to prevent implementation of medical marijuana by various states and territories. So I think it appears that the Trump administration is taking almost the same approach as the Obama administration, and they're recognizing the conflict, but they're really hands-off on this issue. So where is marijuana legal now? Currently, it's legal in 20 states and the District of Columbia, Guam, and Puerto Rico. But the laws vary on how much marijuana can be possessed, where marijuana can be used, and what it may be used for. So this is where I go back to the slide I had talked about a few slides ago with regard to, even if you're using it in a state where it is considered to be legal, you still have to be using it pursuant to that state's laws. So what may be legal in Colorado for use of marijuana may not necessarily follow when someone goes into the District of Columbia. If we just take a comparison look at our jurisdiction, meaning D.C., Maryland, and Virginia, here's where the laws are now. In the District of Columbia, recreational use is lawful. In D.C., we call it homegrown home use. So someone can grow their own marijuana in their home, and they can use it in their own home. However, in Maryland and Virginia, recreational use is still unlawful. When we talk about medical marijuana, it's lawful in the District of Columbia and Maryland. It's unlawful with regard to some specific areas that Mark is going to talk about. And sometimes because we talk about marijuana, we then have to get into the impact on employers. And so we talked about drug testing by employers. There are no laws in the District of Columbia regarding an employer's ability to test employees or applicants for marijuana. There are some statutory laws on drug testing by employers in Maryland. Virginia will only apply to employers who are contractors with state entities. So unless you fit in one of those categories, there's no laws on the books in Virginia with drug testing by employers. The key thing to remember here is that medical marijuana is no longer, quote unquote, a trend. More than 30 states have laws legalizing marijuana for the treatment of medical conditions. 9 states have decriminalized the personal use and possession of marijuana entirely. Marijuana, again, still remains legal under federal law. And in 2018, Attorney General Sessions repealed Hold'em, which largely left marijuana enforcement to the states. So here we're pulling back the state's authority to do certain things. State-run medical marijuana facilities are still protected by federal legislation. The net effect has been an increasing tolerance of marijuana use and perhaps in the near future, somewhat of a normalization of marijuana in our culture. In addition, cannabis products are increasingly available, and not just for humans, but for our pets as well. We're seeing a widespread use of how cannabis can be used, not only for non-humans, throughout the United States. When marijuana is legal in a state, if only for controlled medicinal use, but illegal under federal law, however, it raises a lot of questions for employers. So in addition to that conflict with regard to an individual's personal use of marijuana, we also have this conflict with regard to how does an employer treat these issues. So the first thing is you need to know your cannabinoids. Cannabis contains at least 9 major active ingredients. And for most of us, we are not well versed in cannabis, but for those people who have open dispensaries and everything else, they're very well versed in this knowledge. Most people commonly know THC, which is the psychoactive agent that's found in cannabis. That is the agent that is particularly valuable for managing pain and reducing inflammation. It also has a great effect in reducing nausea and vomiting and stimulating appetite. Other common uses include aiding sleep, managing glaucoma, reducing muscle spasms, and protecting the nervous system. So I think THC is probably one of the ones that we have heard about the most. It's been used to treat, I believe, cancer patients. We're hearing more about now looking at how to use it to treat young adolescents that may have some sort of muscular dystrophy or other disorders. But this is the one that we hear about the most. But then there's also CBD. CBD is cannabinoid, which does not produce the same high effect as THC. So again, THC is that agent that has the kind of psychoactive effects to it. CBD, however, is useful in treating medical conditions such as epilepsy, anxiety disorders, and chronic pain. It can contain some tangible amounts of THC, but THC is not the active ingredient, so to speak. And under Farm Bill passed in 2018, CBD manufactured from industrial hemp is no longer a Schedule I narcotic. So here is where we've seen an adjustment under the federal law for this particular active ingredient of cannabis. And now I'm going to turn it over to Mark.
Thanks, Tiffany. Good afternoon, everyone. So we've gotten a pretty good overview of where the federal government still stands on marijuana in general, and in some cases medical marijuana. And we also know that states have been moving forward in passing their own laws regarding medical marijuana. And if you've been watching or paying attention to the news recently, Virginia also passed some new changes to the medical marijuana statutes that it had in place. So you may be thinking, why on the previous slide did we still show Virginia as labeling marijuana in general possession illegal? Well, because that's the case here in Virginia. According to statute, except as authorized, it's still unlawful for any person to sell, give, distribute, or possess with intent to sell, give, or distribute marijuana. Okay. So what has the state been doing then with these, quote unquote medical marijuana laws it's been promulgating? Well, Virginia, compared to the other jurisdictions, is fairly in its infancy in trying to implement a medical marijuana regime. It's been taking baby steps since 2015, and this year, 2019, has seen the most recent expansions of what those steps are. So where are we now? Well, right now, possession of marijuana, including medical marijuana, still remains punishable as a misdemeanor, potentially resulting in jail time and fines. But the state has allowed an exemption for an affirmative defense against prosecution for other forms of medical marijuana. Okay, so what does that mean? We'll get into that in a second. Okay. The possession is limited to cannabidiol oil or THC-A oil, and the possession must be a result of a written certification that's issued by a valid practitioner. The changes that you saw this year include an exemption now for an individual that either a patient or their parent or legal guardian may designate as a registered agent for the purposes of receiving the cannabidiol oil or the THC oil pursuant to that patient's valid written certification. the types of individuals that can now issue these written certifications has also been expanded to include physician assistants and nurse practitioners. The type of available formulations has been expanded beyond just oils. So now the dispensaries are going to be able to serve things like lozenges, lollipops, other types of ways for people to ingest the cannabidiol oil and the THC oil. And then students also can now possess these forms of medical marijuana on elementary, secondary school property, again pursuant to a valid written certification. And this slide is not an exhaustive list of all of the changes that have been made recently, but they're the most applicable, I think, to the people that are in the audience today. So some really important definitions for us to know as potential individuals and entities that are going to be subject to these laws. Tiffany had talked a little bit about what THC is in general and what CBD is, or cannabidiol oil is in general. But you must remember that in Virginia and all the other states that Tiffany discussed, you're subject to that individual's state laws. And in Virginia, cannabidiol oil and THC oil mean very specific things, right? So in the case of cannabidiol oil, it means any formulation of processed cannabis plant extract that contains at least 15% cannabidiol, but no more than 5% tetrahydrocannabinol, or a dilution of the resin of the cannabis plant that contains at least 5 milligrams of cannabidiol per dose, but not more than 5% tetrahydrocannabinol. Okay, this definition is one of the changes that was recently made this year, and you should note that these changes are set to go in effect on July 1. So if you go look up the definition now, you'll see that it's slightly different. Okay, the main change to the definition is that initial phrase, any formulation, and that's what's going to allow patients and dispensaries to carry other forms of medical marijuana than were initially approved. Okay, THC, this should say THC oil means any formulation of processed cannabis plant extract that contains at least 15% tetrahydrocannabinol acid, but not more than 5% tetrahydrocannabinol, or a dilution of the resin of the cannabis plant that contains at least 5 milligrams of tetrahydrocannabinol acid per dose, but not more than 5% tetrahydrocannabinol. And then now, practitioner means a practitioner of medicine or osteopathy licensed by the Board of Medicine, a physician assistant licensed by the Board of Medicine, or a nurse practitioner jointly licensed by the Board of Medicine and the Board of Nursing. Okay, so we've talked about that there is this exemption now for folks who have a certain form of medical marijuana pursuant to a written certification. Well, what is that? Okay, it's a form that's provided to licensed practitioners of medicine, nursing, or osteopathy who have registered with the Virginia Board of Pharmacy to issue certifications, and it's only good for up to 1 year. Okay, so very important to understand here that these folks who are providing these written certifications, again, are licensed and registered with the Virginia Board of Pharmacy. That's a very important step, that patients and anyone else who, as a registered agent, is picking up the forms of medical marijuana must remember about the written certification that they have in hand. We would show you what this written certification looks like, except that it's generally not available to the public, and for obvious reasons. Okay, this form contains the practitioner's name, address, telephone number, and signature. It also contains the patient's name and address, the date of issuance, and the date of expiration. So as we said earlier, these written certifications can only be good for up to 1 year. And so that's, again, another thing to remember as a potential registered agent. But they don't always have to be good for 1 year, and there can be a date of expiration that terminates that written certification sooner. Okay, you should also remember that the patient that's issued a written certification must also register with the Virginia Board of Pharmacy, and they cannot register before receiving the written certification. Okay, when we talked about baby steps earlier about Virginia law, medical marijuana was initially issued to address very specific types of ailments. Now, these written certifications may be issued by a practitioner for the treatment of or to alleviate the symptoms of any diagnosed condition or disease determined by that practitioner to benefit from the medical marijuana use. Okay, so why do we say that Virginia still holds medical marijuana possession as an illegal act? Okay, well, that's because of the way the General Assembly has written the laws. Okay, instead of quote unquote legalizing medical marijuana, they've provided what's called or what they've identified as an affirmative defense. Okay, so having a written authorization or a written certification from a practitioner who is authorized to give one does not may not prevent possessors of medical marijuana from receiving any sort of citation. Okay, and part of the reason of some of the ambiguity in this area is because even though we have these laws now in place, there haven't been lots of regulations put in place to address some of the practical issues related, and those are being actually developed right now. So, you know, earlier we talked about how there were baby steps. Well, that's also the case in promulgating the regulations that people need to have in place to actually be able to do some of the things that the laws allow them to do. So when we're talking about what a written certification does, at this point, we know that it serves as prima facie evidence that such possession was based on a valid written certification. So again, you'll see, we're not saying that written certification makes possession of medical marijuana legal. We're just simply saying the best that we understand right now is that having that written certification simply means that your possession is based on that written certification. Okay, the statutory process that's provided is to have a copy of the certification provided in advance of any court proceeding. Okay, and there hasn't been a lot, obviously, of testing of how this procedure is going to take place, and it's still even unclear if you have this valid written certification and are caught with possession, how law enforcement may treat that. That's still also some of the process that's being worked out right now. Okay, so I'm going to take a second to address a question that we just got. It says, how come I see CBD oil for sale in health food stores on the internet? Okay, so the one thing that we haven't talked about on this webinar is that CBD is also a byproduct of hemp. And as I think Tiffany mentioned it in one of the earlier slides about how hemp has been in some ways legalized at the federal level. So, not knowing what that specific product is that was discovered on the internet, you will see some of these types of products that are derived from a different product other than the marijuana product. Okay, and then we also have another question that says, if an individual has an oil that meets the state definition and has the required certification, are you saying it's legal? The answer is no. We're not saying it's legal, and in fact, the understanding that we have right now is that in general, medical marijuana possession is illegal. All right. We don't know why the General Assembly has sort of addressed it this way. There may be changes to the way they approach it as medical marijuana laws evolve across the states and at the federal level. But right now, the circumstances are that there's simply this exemption by way of having a written certification to help you out in case of any particular court proceeding, right? We don't even know if this written certification is going to have any impact in any type of interaction with law enforcement. Okay, one of the beneficial changes to the law for the members of this audience is this new concept of a registered agent. One thing that you're going to need to keep in mind is that as business entities, there's also a concept of registered agent related to being able to transact business in the state. So you'll want to make sure that you have those two processes sort of understood so that there's no confusion there. When we're talking about registered agents for purposes of medical marijuana laws in Virginia, we're talking about an individual that's been designated by a patient who has been issued a written certification, or if that patient is a minor or incapacitated adult, then that agent is designated by the parent or the legal guardian of the patient. And this registered agent also must be registered with the Board of Pharmacy. Okay, we don't know exactly the scope of what's involved in being a registered agent. We simply know what the law tells us. And in that case, It simply says that it's an affirmative defense for an individual if that individual has been designated as a registered agent from prosecution. Okay, I believe we're expecting regulations to be promulgated by the Virginia Board of Pharmacy, but I looked recently, and it doesn't appear that there's been any movement yet in that space. Okay, so you have laws now that say you are exempt from prosecution if you're a patient or a registered agent, your possession is pursuant to a valid written certification, and that certification was given to you by a licensed practitioner. How do you get the medical marijuana? Well, the bottom line is right now, you can't, because they're still in the process, the state is still in the process of working with the dispensaries to put those facilities in place, right? So in the time being, what has been happening? Well, people have been transporting marijuana into the state from other jurisdictions, okay? What are the implications there? Well, like general possession, transporting marijuana into Virginia remains illegal. Okay, it's unlawful for any person to transport into the Commonwealth by any means with intent to sell or distribute 1 ounce or more, actually 5 pounds or more of marijuana. So I want to talk briefly about a case in Virginia that speaks very broadly about the state of the medical marijuana laws. Okay, you have the case of Chianelli versus Commonwealth. This was a case that was litigated in 2015, and essentially Mr. Chianelli, he was a proprietor of a business that sold drug-related paraphernalia, so bongs, stickers, other types of tools to help or to assist a person in ingesting marijuana and other forms of herbs. Okay. At that time, you did have some basic medical marijuana statutes in place. Okay, and so what Mr. Chianelli, the question that he raised is, well, if marijuana possession in general is illegal, but you have these statutes that say in certain cases you're not going to be prosecuted for possession of medical marijuana, how are we, the average citizen, supposed to know what we're allowed to do? Okay, and the bottom line is the court in that case made very clear that medical marijuana possession is still illegal except in certain cases. Okay, what they said is, when attempting to harmonize these statutes, it is important to note, rather than legalizing the possession of marijuana, what the code actually does is provide legislative immunity from prosecution to those who meet the statute's requirements. Okay, so that's sort of the state that we're in now in Virginia, is that medical marijuana possession still is generally illegal, but in the case that you have this written certification, you have a way to deal with any potential prosecution issues. All right, so what is this, in terms of the statutes that are now in place in Virginia and the distinction from federal law, where does this put senior care facilities? What kind of state does this put senior care facilities in? Can medical marijuana possession and use be prohibited from a senior care facility? Well, I think if you look at the laws generally, there's nothing that requires a senior care facility to allow use of medical marijuana on its premises, right? At the federal level, it's still illegal, and in general, possession of medical marijuana in Virginia is still illegal. Now, we'll talk a little bit in terms of, the way that the laws implicate the employer and employee relationships, but in terms of the senior care facility and the patients, there aren't a lot of laws right now that are that put specific obligations on the facility to allow use. Do you have any thoughts on that, Tiffany?
No, I think what you stated is accurate here. I think you just have to really keep in mind the difference between the state and the federal law. But the key is, especially if you have any sort of federal funding coming into your facility, that you really need to be mindful that any type of medical marijuana would be prohibited.
Yeah. So, can senior care facilities store medical marijuana for residents? Well, if you're looking specifically at the new Virginia law that's been passed that allows this concept of a registered agent. Registered agent in general refers to an individual. It doesn't refer to an entity, and it's also designating that person as somebody who can receive the medical marijuana, not necessarily and possess it for purposes of transporting it to the patient. It's not quite clear how this concept of registered agent is going to apply to anyone as it relates to sort of long-term possession for any particular patient. And hopefully this will be something that is addressed in the regulations that everyone is waiting for, but we'll have to see. I think if we look at how the courts strictly interpreted the language of the medical marijuana statutes in Chianelli and the way that the law reads right now, I think the conservative view is that there's likely not anything that allows senior care facilities to store medical marijuana.
We had a question come in, and I think this is a good segue for something that Mark was recently talking about. And the question is, living in assisted living, administering residents meds, can a licensed nurse or RMA administer CBD oil with a doctor's prescription for regulation purposes? What are your thoughts on that, Mark?
Yeah, so I would go back again to what I just talked about, and the concepts that right now all we have to rely upon is the statutory language that the Virginia legislature has given us. And since there haven't been any regulations that have come out yet in terms of some of these new concepts that they've given us, in general, it's understood that the only person that can possess medical marijuana is the patient or if that patient's a minor, the parents, the legal guardian, and now the registered agent. Okay, those are the only individuals that are allowed to possess marijuana, medical marijuana. So if we're talking about somebody that's assisting them, I think it's a gray area, and it, you know, it's like there's a good probability that those individuals would not fall within any of those categories that we just described.
And I also think, for the purposes of this question, it also talks about with a doctor's prescription. And I think the statute is very clear. We're talking about written certification, which
right.
is different from a doctor's prescription. And this goes back to the first, earlier in the webinar when I was explaining, you have to be in compliance with the state laws. So here, generally a prescription for something may be okay, but when we're talking about marijuana, Virginia law is very specific. It does not mention prescriptions. It mentions a written certification that must be in a certain form, and it's issued in a certain manner. In addition, the person who is the patient also has to register with the Board of Pharmacy, and they can't register before receiving that certification. So there are a lot of other things that come into play with regard to this question, and I think you have to be very careful to look through those state statutes that Mark had mentioned to make sure that you're in compliance with each and every one of them with regard to the definition of a registered agent, a practitioner, and also the written certification.
Mm-hmm. So, some of these questions sort of beg the question, well, what kinds of things do we need to have in place at the organizational level? What kinds of policies and procedures do we need to be contemplating now with these changes to the medical marijuana laws in Virginia, and then, the trend that's been going on at the national level? Well, we've talked about a few of them. I mean, you definitely should have policies and the procedures related to any sort of use by residents. You also need to have policies and procedures in place related to your employees. That is something that we're going to talk about in a second. You can certainly have policies and procedures related to how medical marijuana is coming into and leaving your facility. And then you can also have policies and procedures related to, the time and the place of any potential use. And this is, again, not an exhaustive list of the things that you need to be thinking about. What's really important is that you need to be thinking about, all of these issues, and you need to have, a comprehensive set of policies and procedures in place. And that's something that you should work with legal counsel to develop. Okay, and then we talked about this earlier. If medical marijuana is not available right now in Virginia, can you allow your residents to bring it in from other jurisdictions? Generally, no, right? Generally, the law says that it shouldn't be transported into the state. And so, again, if you want to have policies that prohibit that type of activity, you're supported in being able to do that.
So just briefly, I'm going to talk about medical marijuana and the employer. And why this has become one of the more recent hot topics is because when you're dealing with the Americans with Disabilities Act, and depending upon the size of your organization, you may or may not be covered by that federal statute. But generally speaking, even if you're not covered by that federal statute, normally there may be a local statute like the Fairfax County Human Rights Act or the Arlington County Human Rights Act, or some local statute that still protects individuals with disabilities. And so that comes into play when we're talking about medical marijuana, because now we're talking about it from the perspective of employees that may be using medical marijuana for some sort of disability. And so here's some things you need to think about. You know, what about the ADA and the state's non-discrimination laws? What about the interplay there? Because it's still unlawful in Virginia. What about drug testing? What if I have an employee that lives in the District of Columbia where pretty much recreational use and medical marijuana is lawful, but they're driving to Virginia to work at a facility I have in Virginia. They're using the drugs in DC, but they're coming to Virginia, which means they may end up testing positive on a drug test. You know, you have to think about how will this impact work safety. In the example I gave, you know, hopefully the person is not showing up to work under the influence of some sort of medical marijuana or recreational marijuana, but you have to be concerned about how could this impact work safety because of what may not be lawful in Virginia could be lawful in the surrounding jurisdictions. And what if I receive federal dollars, you know, Medicare and Medicaid, or do business under a federal contract? I can tell you this is absolutely one of those that if you are receiving any sort of federal funding, you do want to make sure that you are in compliance with the law, because most of those contracts will prohibit any sort of marijuana on your facility. And then you need to think about how do you handle conflicts between federal law, state law, and then your company policy. And if you handle these things incorrectly, could you be opening yourself up to some sort of risk for a wrongful discharge claim brought by an employee? Because again, in that example I gave, maybe there's an employee that has a documented disability that uses the medical marijuana in the District of Columbia, doesn't impair the employee from their actual job duties when they're coming to Virginia, but maybe there's something else that's happening as a result of their job performance and they're fired. And they say it's because of their disability and their use of that medical marijuana in the District of Columbia. You know, these are issues that are all starting to come up as a result of the status of the law. So how can an employer comply with its obligations under the disability laws? Well, the first thing that you need to keep in mind is every scenario is going to be an individual scenario. And so there is no one-size-fits-all approach. Everything needs to be evaluated on a fact-by-fact basis, because what may work for one scenario is not going to work for the other, even if the facts of the circumstances may be similar. Generally, what is that process going to involve? Well, the employee needs to make a request of some sort for an accommodation. Keep in mind, they don't have to use the magic words, I need a reasonable accommodation, but they need to impart enough so that the employer knows that they're seeking some sort of accommodation or some sort of break in some sort of rule or policy. The request can also be verbal. Again, the preference is that it be put in writing, so there's some documentation of it, but the request can be verbal. After that happens, you need to have an open dialogue about the request. You need to discuss it to determine whether or not you're able to meet the request, or could there be some alternatives if you can't meet exactly what it is that's being requested. And then, if necessary, maybe the disability is not obvious, or maybe the nexus between what the accommodation they're seeking and their disability is not obvious, then you need to ask for doctor's input if that's necessary. But keep in mind that the interactive process when evaluating a request for accommodation is always going to be interactive. You know, it just doesn't end with the employee makes a request for accommodation, the employer says no. It's interactive. You need to continue to talk and see if you can find some sort of way to accommodate the employee. And the end of that conversation may be that we've tried whatever avenues were available and we're just not able to do it. So are employers required to make accommodations under a drug-free workplace policy? What should an employer do if an employee who is a qualifying patient uses marijuana in a manner consistent with the law to treat a disability and tests positive on a urine sample for marijuana use? This is that example I gave where somebody could be coming from Maryland or the District of Columbia into Virginia to work. They're not using it on your facility grounds, but they're using it in another jurisdiction where it could be legal. Does the fact that the employee is a qualifying patient in some other state using marijuana in accordance with that state's law prohibit the employer from disciplining or terminating the employee when they come into Virginia? Can an employer grant a reasonable accommodation to an employee who uses marijuana for legal off-duty use, notwithstanding your drug-free policy? These are some things that an employer has to consider, and I can tell you that there is no bright line answer to a lot of these because they're going to be up for debate. And especially in this area where you have differing laws between all of the neighboring states, this is one of those where you should surely consult with legal counsel to work through the factual scenarios each by each to determine how you need to handle the accommodation. But just in general, I can tell you that when it comes to handling requests for accommodations, you just want to make sure first, does the, think about, do you have to permit it as a reasonable accommodation? Is it necessary? It could be, but this is when you need to engage in the interactive process. Again, maybe the first step is we really don't even understand the disability and why you need this as an accommodation because we don't get the nexus between the disability and your use of medical marijuana. You need to start that process to get those things clarified. Could there be some alternatives to granting an accommodation to allow somebody to use medical marijuana? Surely, you could think about a modified work schedule, possibly granting them some leave of absence if we're talking about some sort of a disability that could be treated in finite periods of time, modifying job duties as necessary, transferring them out of safety-sensitive tasks. Maybe it's somebody that we know that they're using medical marijuana and they live in Virginia or Maryland, but they're also the person who is driving our products or transferring our residents from different places in Virginia. Maybe you want to consider transferring them out of those types of duties. And also allowing for the use of products possibly that have some other ingredients in them. Again, this is going to all be specific to whatever the laws are. And in Virginia, Virginia's laws are still kind of up for debate, unlike Maryland and DC, where the laws are pretty clear on what can and cannot be permitted. So at this time, we're going to open it up for any sort of questions. Okay, so it looks like we answered some questions throughout the presentation, so it looks like we don't have any additional presentations, but Mark and I would like to provide you all with our contact information. One, so that if you have questions that come up after this presentation, you'd like to email us about those, you're welcome to do so. And in addition, we look forward to receiving your feedback. If there are other issues or topics that you think would be helpful for your organization, we would be interested in hearing about those to see if we could put together a webinar to address some of those topics.
Okay, well, that's it for today. We thank everybody for attending, and we look forward to any additional questions that you want to throw our way. We're definitely open to assisting in any way that we can. Okay, everybody have a good day.
Thank you.